Hi everyone, I'm Neama Rahmani, president of West Coast Trial Lawyers, and today my team is going to test me on legal jargon. Let's see how I do. The burden of proof is what the plaintiff or the government needs to meet to prove their case. So the burden of proof in a civil case is lower. It's preponderance of the evidence. Slightly more likely than not, or 50.1%. The burden of proof in a criminal case is the highest standard under the law, beyond a reasonable doubt. Preponderance of the evidence is the burden of proof in a civil case, a case about money. Slightly more likely than not, 50.1%. Amicus brief is a friend of the court. So generally what will happen is parties to an appeal will submit their briefs, their opening briefs and their reply briefs. But sometimes other parties realize the importance of the case and the legal issues presented. So they will submit their own briefs in support or in opposition to the legal issue that's being litigated on appeal. And sometimes courts themselves will solicit briefs from other attorneys or entities because of the importance of the issue being litigated. Inculpatory evidence is evidence that tends to prove that the defendant is guilty. Contrast that to exculpatory evidence that tends to prove that the defendant is innocent or not guilty. Habeas corpus is an old legal principle from the UK that essentially allows a federal court to review a conviction to make sure that certain rights weren't violated. It's an old equitable remedy. So the way it comes up now is, let's say someone's convicted, the defendant will do is appeal, which is a direct attack on the conviction, but they can also file a petition for a writ of habeas corpus and ask a judge with a fresh set of eyes to review the conviction to make sure that it was not unlawful. A tort is a type of cause of action. It's not contractual, it's not based on property. It's actually what we do here at West Coast Trial Lawyers. So the two most common types of torts are intentional torts, such as assault and battery, defamation, those types of things, and unintentional torts, which are negligence. If you plead nolo contendere, that basically means no contest. You're pleading not guilty, but you're saying that you do not contest the charges. For all intents and purposes, the effect is the same if you plead nolo or you plead guilty. But some defendants like to plead no contest or nolo because they're not actually admitting guilt in open court. Interestingly, some judges, particularly federal judges, don't allow nolo pleas. They're much more common in state court. There's two types of due process. There's procedural due process and substantive due process, but it essentially means that you as a citizen, as a defendant, you're entitled to the full protection of the law. So procedural due process means that you're entitled to all the substantive steps that are guaranteed under the Constitution. So let's say you're arrested. Procedural due process would mean that within a certain number of days of your arrest, you're arraigned. You're brought before a judge where you're going to plead guilty or not guilty. Then the case will be set for a preliminary hearing or potentially a grand jury indictment. All those processes are in place to protect you. An important part of our procedural due process is our system of open courts where everyone can observe what's happening. Substantive due process are things like equal protection under the Constitution, the right to be free from unlawful searches and seizures. So essentially, between the procedural and the substantive due process, it makes sure that criminal litigants, especially, their rights are protected. During jury selection, the parties will strike jurors. Now, if you can prove that a juror is biased, they can't be fair and impartial, the judge will excuse them. But the parties also have a certain number of peremptory challenges. Those are strikes or challenges they can use for any reason, as long as it's not a prohibited reason, such as race, religion, or national origin. Yeah, a writ of CERT. So there are certain types of appeals that you can do as a matter of right, usually to the Court of Appeal. So there's a trial court, and in every jurisdiction in the United States, whether state or federal, you have the automatic right to one appeal to the appellate court. A writ of cert is to the highest level court in the jurisdiction. So it could be your state Supreme Court, or when you're dealing with federal cases, to the United States Supreme Court. Now, a writ of cert is a discretionary appeal. That means that the highest court in the state or in the United States Supreme Court, they don't have to accept the appeal. They choose what cases to accept and which cases to not accept. And the vast majority of cert petitions are actually not accepted. That was easy. Thanks for watching. Like, subscribe, and hit the bell for more notifications.